When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individual.
If you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation.
Justice must not only be done, but it must be seen by all to have been manifestly done.
Every citizen has a right and every citizen has an obligation.
That a plea of ultra-virus acquit or convict is very different from the plea of pardon.
Trespass is that act that interferes with the peaceful.
No matter how minute
this, right?
No
matter how minute.
Who comes to equity must come with clean hands. Hello out there, you are welcome to another fresh episode of the program Justifying Nigeria on ACNN television, reaching you from Abuja. On today's episode, our subject of discussion will be the legal concept of arraignment. My name is Anozechi Nomso, your anchor. For general understanding, the word arraignment is a legal process which calls someone to court to answer an indictment. This means that once an individual is arraigned in court, such a person has a case to answer. Usually, a criminal trial commences upon arraignment and ends with sentence, discharge, and acquittal depending on the outcome of each matter. This is why an accused person is usually called upon to make his plea upon arraignment. Once an accused person pleads to a charge, the trial has commenced. Similarly, in order to determine whether an accused person was given a fair trial within a reasonable time, time only begins to run from the plea. The questions here are, why is the time of arrest of the accused person not considered as at the time of his arraignment? Are there stages of arraignment? Does lack of compliance of these stages affect the competence of a trial? What is the position of law if the accused person is not physically present in court on the day of trial? With me in the studio to address all this and make sense of it all is Barrister Onyinye Dike. She is an experienced Abuja legal practitioner, associate partner at the law firm of Emeka Nwale & Co., and also a member of the Unity Bar here in Abuja. You are welcome to the program.
Thank you very much, sir.
Now, we talk about arraignment, but you agree with me that when we speak about arraignment, there are some of our viewers out there that are not lawyer like you, which would like to understand what arraignment is all about.
Yes,
so, to
right.
better understanding of our viewers and based on legal perspective, what is arraignment?
Okay, so arraignment can be seen as that process of bringing an accused person to court for the purpose of reading out the charge or information against him to his own understanding and to the satisfaction of the court, and then he takes his plea.
Okay, that means there are three things there. First of all, they will be reading based on the understanding of the accused person and satisfaction of the court and the plea. So this is basically what arraignment is all about. Now, are there stages of this arraignment? Are there stages?
Yes, there are stages of arraignment.
Okay, please educate us.
The first stage of arraignment is the accused person is brought to court and led to the dock unfettered. And
please, you are speaking much, but you know, most of us here, especially we didn't go to school or we didn't you know, you people are lawyers and you people believe that you are learned. That when other people are educated, you people are learned because it takes an extra mind to be learned. But now, please, calm down. You talked about fettered now. You talk about dock. Please, what is dock? Explain those things for us to understand the word fettered.
Okay. A dock is where an accused person is placed to either stand or sit in court.
Okay, that's what is called
usually
a dock.
in front of the court to the side. That's what's called a dock.
Is it different from witness stand?
Yes, different from witness stand. An accused person in criminal trial, he stands there as an accused in a criminal trial. Witnesses are not accused persons.
Okay, so they can't be in the dock.
They can't be in the dock. You stand in the witness box.
Okay,
yes,
okay.
But accused persons stand in the dock.
Is there any circumstance by which the accused person will sit?
Yes, as I said, he can either stand or sit. Depending. Maybe if he's not fit to stand, he could sit. Exactly.
Okay, that is what the stages you are talking about. You know, you have to go ahead and pick it up from there.
So he's placed in that dock.
You talked about the fettered. What is that
Yes.
fettered?
So unfettered means without restraints. For example, no handcuffs, no leg chains.
Okay,
You get?
unfettered.
Unfettered.
Okay.
So he's saying, except the court sees cause to do otherwise.
Okay,
Yes.
It's not exclusive right of the accused person that
No,
it
generally that is what it should be.
it should be.
But then in very, 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 very maybe where the court sees that keeping him without restraints may
cause
harm,
damage.
exactly, or damage.
Okay, so it's based
Yes.
on the court to give the order.
Exactly.
Very well.
Yes,
But
but
generally, it
he
should
should be placed there unfettered. Do you
Okay.
get this is then in section 271 of the Administration of Criminal Justice Act. Yes. So he's placed there unfettered. That is the first stage. Yes. The second stage is the registrar of court or the officer of court reads out a charge or information to the accused in the language he understands. Meaning, if he doesn't understand English language, an interpreter has to be brought to interpret in the language he understands at no cost whatsoever to the accused, to the satisfaction of the court, and the court must record this plea. Then the third stage is the accused person, takes his plea.
Please, what is that plea? Because let's understand,
good.
because the plea,
okay.
can you just demonstrate it? Maybe
Yes.
maybe if they read something, this, for example, now is the charge.
Yes.
They finish reading it. How does the plea look like? They will now ask you guilty or not
Yes,
guilty.
exactly. They will ask you, what do you plead to the charge? Or what do you plead?
So,
And then
okay,
the
you
accused
see.
person could plead either guilty, he could plead not guilty, he could plead not guilty for reason of insanity.
Okay, those things are what is called plea.
Exactly, that's what's called plea.
Okay, just for us to
Exactly,
understand
yes,
that.
yes.
Okay, you are going, is that all the stages? Go
Yeah,
ahead.
those are the three stages of arraignment.
Okay, first of all, the
Yes.
person must have to be, the
Led.
charge must have to be
No, he
read,
must first, he must be led and placed in the dock,
unfettered.
unfettered.
Okay.
Then the charge or the information is read to him, read to the accused person.
To his
Then thirdly,
understanding
to his understanding
and
to the
satisfaction of the court.
Then the third stage is he takes the accused person, then pleads to that charge or information, and the court takes record of that plea.
Okay, that
Yes,
is
so
actually
that's
the stages. Okay,
Yes.
thank you very
You're
much.
welcome.
Now, when you look at these stages you just outlined,
Yes.
whereby none or all of these stages are not complied with, can somebody say it will affect the competence of a trial?
Yes, of course. Like, definitely. Where the state valid requirements, where these requirements of a valid arraignment are not followed through, it goes down, it nullifies the whole proceeding in its entirety.
No matter how beautiful the charge
Yes,
might be.
it nullifies the proceeding
How
in its
and what are
entirety.
your reasons?
And let me just quote a case. This was a case. It was seen in the case of Kajubo versus the state. You get and also in the case of IGP versus Rosek. So why this is so is arraignment is the commencement of a criminal proceeding. Yeah. So when the accused person has not pleaded to any charge, or maybe, for instance, no charge was read, as in the case of IGP versus Rosek, no charge is read. So what is he pleading to? What is he pleading to? The whole essence of the proceeding is there's a charge, an offense, and then he's pleading either guilty or not guilty to that offense. So there's absolutely no use. Then the whole proceeding can be seen as a nullity, can be seen as there is nothing. Why? Because you cannot place something on nothing
and expect
it to stand. It will collapse.
Definitely.
Exactly. So that's just it.
So it means that whatever thing that is being done, those stages must be followed.
Yes.
Now in a circumstance by which, let's say, the accused person is an Igbo man, and the charge was read in English, and he said he didn't understand it, and they are looking for interpreter. There is no interpreter, for example. What happens with the charge commence, or the court must make sure to get an interpreter?
The court will make sure to get an interpreter.
So that means the charge, the process will be stalled until the interpreter is
An
brought.
interpreter must come. He has to understand the charge being read against him. He has to understand it. Without it, there's no use, because he has to plead. And he cannot plead to something he doesn't understand. Do you get? So they have to wait. They have to get an interpreter.
In as much as they caught him doing the act, is immaterial, provided
Very,
he has been charged, because he must understand it.
Yes, very, very material. Very, very material. You can't. The presumption of innocence is too strong. Section 36. You can't just.
Oh,
you can't
is
just
even
because he was caught
is
in
even a
the act.
constitutional
Yeah,
matter?
no, I mean you just ask the question that if he was caught in the act,
Yes.
you get, he's still presumed innocent until contrary proved.
No, excuse me, barrister. Let me come.
Yes.
There's somebody who's been charged for rape.
Yes.
And maybe before that time they caught him in the act. They even saw him. And they brought him inside the court. And you are telling me that the constitution say as that material before the trial commenced that he's been presumed innocent.
Until contrary proved. Beyond reasonable doubt in criminal cases, yes.
That's the law.
Yes, that's the law. The law would rather let 100 guilty persons go free than one innocent person go down. So that's the law. Yes.
The law will rather let 100 guilty persons
Go free
to go down to the innocent
One
persons.
innocent.
So that's why they have to put all these things in consideration.
Exactly.
Thank you very much.
You're
Now,
welcome.
suppose that charge is being read, because this is very important, it's getting interesting. That charge is being read to the understanding of the accused, but the court or the judge in this circumstance is not satisfied. What happens?
Well, it doesn't exactly nullify or make the plea defective. It doesn't, if it is not to the satisfaction of the court, it doesn't actually make the plea defective. There's actually a case to back it up, Sunday Amala versus the state.
Okay.
So I don't, it's important that the court is satisfied, but if at the end it's found that the court is not satisfied, it does actually render the plea defective. Yes.
Thank you very much.
You're welcome.
We are going to answer some of the questions relating to this, but that will be when we come back from break so that
Okay.
our viewers will learn more on
Okay, sure.
arraignments.
All right.
Please, viewers, do join us again. Hi, you are welcome to the speaker on ACNN television, reaching you from Abuja. The speaker is a platform by which we treat some topical issues happening in the polity. On today's episode or segment, we are going to be looking at a fortunate Nigeria or an unfortunate Nigeria. My name is Anoze Chinomso. When we attribute the word fortunate to anything or anybody, it means that such individual or thing is favored, successful, and prosperous. It therefore entails that when a community is fortunate, that community or environment is advantageous in nature, and as such, the people dwelling in that place experiences happiness, peace, and developmental growth. Of course, I need not to stress myself to convince you that the reverse will always be the case in an unfortunate circumstance. With the kind of heartbreaking and sorrowful things going on in Nigeria, I'm moved to say that we are not living in a fortunate Nigeria, rather we are living in an unfortunate Nigeria. And we all contributed to that unfortunate Nigeria. Yes, you and I. This issue of when you benefit from your own wrong or that of the wrong of your brother, sister, friend, or neighbor simply because he or she shares the same ethnicity with you is also a contributing factor to an unfortunate Nigeria. It is easy to point an accusing finger to others, but can never do such to ourselves. We feel very comfortable to see virtues in ourselves and see vices in others. But believe me, this is how the unfortunate Nigeria began. This is because nobody destroyed Nigeria but you and I. Oh yes. We must tell ourselves the truth for once at this point, that it is the Igbo politicians in collaboration with some of the traditional institutions in that area that impoverish Igbo land when they divert money meant for public use to their private pockets. The average Yoruba man should be told that it is the Yoruba political elites and their cohorts they always celebrate have tactfully and successfully made life unfortunate for them and not an Igbo Hausa man. The Hausas, Fulanis, Kanuris, Iberos, thieves, Idomas, Igedes, Egalas, Ibiras people, etc. must be aware that it is not the man from Nise in Anambra State, or Kano, Obo in Imo State, or Bende in Abia State are responsible for their own misfortune, but their governors, representatives, and senators whom they have voted for or refused to vote for have consistently and persistently made the word development to be absent from their dictionary despite the abundance of natural resources in that region. I hope that the Calabaris, Ijos, Owas, Urubus, Ishan, Benins, Ekas, Ikweris, Oshimilis, and others in South will agree with me that it is nobody but their politicians and leaders that are eating their own part of the national cake, and therefore blame them and not others. Those destroying rail tracks and burning down pipelines must be reminded that the evil that men do lives with them and after them. Those who claim to be unknown and go by the word unknown gunmen must be reminded as well that nothing is hidden under the sun. People who are killing, kidnapping, and setting villages on fire in the north, have we ever asked them to stop or punish them for their crimes? Rather, their leaders in that region celebrate and pay them ransom. What an unfortunate Nigeria. Those traditional rulers who dashes chieftaincy titles to unpatriotic people because of money should blame themselves for destroying Nigeria and not others. Pastors, priests, bishops, general overseers, apostles who use Sunday service as a platform to brainwash his members and continue to buy and fly private jets here and there, while hunger is the elder brother of his parishioners, must not blame anybody for destroying Nigeria but himself. The Islamic cleric who negotiates with bandits, kidnappers, and terrorists, and those who are silent in the face of the killings, simply because the killers, the rapists, kidnappers, and bandits share the same tribe and religious faith with them, is a chief architect of an unfortunate Nigeria. Those lawmakers in the National Assembly and the state houses of assembly who uses every budget passage as an opportunity to loot nation's treasury should blame nobody but themselves for changing their names from legislators to legislators. You parents that refuse to teach character and morals to your children, rather you celebrate them when they cheat in examination hall or misbehave, and shout down at their teachers when they try to correct them, is also a wonderful contributor to an unfortunate Nigeria. You landlord, yes, you landlord that increase your rent unnecessarily to the detriment of the tenants. You traded that hike up the prices of goods in the markets. You security personnel, whether police, military, paramilitary, that carry out extrajudicial killings on innocent citizens. You lawyer, defending political monster and political demon, even when you know the truth. You judge that collect money to truncate justice. The medical doctors and nurses selling public drugs and rendering more services in their private hospitals. The minister who tells doctors no work, no pay. Even when doctors are being old for 14 months. It is only in Nigeria that I see doctors looking hungry. What an unfortunate Nigeria. The civil servant who is better referred to as evil servant because of his atrocities in civil service. You civil society thieves using civil organizations and society and groups to siphon money and foster corruption. You special advisor that advises destruction instead of construction. You that betray your colleague in office by acquiring PhD degree, that is pull him down so that you may climb and be a favor staff to the boss. The list is endless. Just add your own. Are all parts of the larger problems of Nigeria. We are not different from people governing us, as our leaders and rulers are drawn from among us. And that is why I still believe that those who are waiting to steal from government are more than those that are already stealing. What an unfortunate Nigeria. In order to justify Nigeria, I therefore speak that until we all begin to see and believe that we are all co-authors of our own misfortune, and not just the politicians, begin to have self-examination and interrogation, endeavor to individually work on ourselves in order to be the change we want to see and become worthy ambassadors and patriotic citizens of this country in order to have a fortunate Nigeria, we shall continue to live in an unfortunate Nigeria instead of a fortunate Nigeria. My name is Anoze Chinomso. I just want to speak. Hello, glad to know that you are still there with us. We're still here in the studio with Barrister Onyinye Dike, who has been explaining to us the things we need to know about arraignments. Now, Barrister, before we went for break, you are trying to tell us that even if a charge is being read not to the satisfaction of the court, but the major thing is that of the understanding of the accused person.
Yes.
Now, the question here is, are there legal remedies available to the accused if any of these they are not complied with?
Yeah, the legal
Maybe, for
remedy-
example, he was brought fettered
Yes.
without the permission of the court, and there's no circumstance that this person should be, tried fettered. Now, after reading the charge, at the end of the day, he did not understand it. He said, no, it's outside, you understand, and it's being read in Igbo. Are there remedies available to him?
Yes, there are. Like, if this is the case, then the accused person is discharged. Like, the accused person regains his freedom, because these stages of arraignment have to be complied with for there to be a valid proceeding. So where any of this stage is not carried out, or any of these requirements are not carried out, the accused person is free. Yes.
So if he is convicted, he can appeal that.
Exactly. He can challenge the judgment of the court by way of judicial review.
Okay.
So that way, that judgment is quashed. Because the proceeding
Quashed is another language that is dismissed.
It's dismissed.
No, now
Discharged.
if that judgment was given in high court, if he wants to seek remedy, which court does he go? It's court of appeal, or because you talked about judgment review or something. Which court does he go now? To the higher court, which is court of appeal.
Yes, he goes to
Okay,
court of
to
appeal.
now challenge
Yes,
that
exactly,
judgment.
Exactly, to challenge that judgment, and the judgment will be squashed.
Okay, now because we are looking at these stages
But
for
it's
us
a
to understand.
judicial review, so you're challenging the proceeding.
Okay.
Not the judgment.
Not the
itself, but
judgment,
the
it's proceedings.
Yes,
Okay.
of the court.
Okay. Now, if he was brought to court fettered, but the charge was read to the understanding of the accused and satisfaction of the court, but throughout all the whole proceedings fettered, and there was no reason, there was no court order by the judge or reason why this person should be, tried fettered. What happens in that circumstance?
The answer remains the same. The answer, if any of these valid requirements of arraignment is not followed through, it nullifies the proceeding. That is how serious the court takes these stages of arraignment. Yes.
Okay, now,
Nullifies it.
thank
As it
you
was seen
very
in Kajibo versus the state, and there are other cases.
the other
too.
cases,
Yes.
plethora of cases.
Plethora of cases.
Now, thank you very much, man.
You're
Now, the issue we talked about, there's this constitutional provision that talks about reasonable time by which an accused person must have to be tried. Now, as at the time of arraignment, can you educate us? When do we start counting time of arraignment? Is it at the time of arrest, for example, if the accused person or the suspect, because he only remains accused when he's being brought to court, if he's arrested, for example, on February 3rd, and he's being brought to court March 10th, when is the arraignment supposed to start?
March 10th.
Oh, all those time of arrest is immaterial?
No, arraignment starts. The stages of arraignment, you say the first is called to the dock, that's where it starts. That's where it starts.
Okay.
Yes.
So every other thing before that time?
No, that's where it starts.
All right.
Yes.
Now, Counsel, you are telling us that whether is unfettered and he did not understand the charge, the judgment will be quashed.
Yes.
Any of them, all of them must be complied with.
Yes, it must be compliant.
Now,
except, remember when I said unfettered, except the court.
yeah, exactly. That's what I'm saying. Now, when that is not available, the court did not say anything and all that, and maybe he was convicted at the lower court or the first court of instance, and he now appeals to a higher court for judicial review. Now, in that place, are they going to look at the trial entirely, or only that judgment? Or only that's the thing that is being quashed? What is it going to look like?
Look at the proceedings of court.
Well, what do you mean by proceedings? From the time of the
arraignment till the end, judgment, sentencing.
Okay, that is actually what the accused person is challenging.
Yes, the proceedings. That's what is called judicial review. They are reviewing, they're challenging the proceedings of court. That the judgment wasn't arrived at to the right court proceedings.
Okay, now, what of in that first court of instance, he was convicted. Now he appeals. Which one is he appealing? Is it the proceedings of the court or the conviction? You understand the question
don't
now?
understand what you're
Now, if, for example, that he was convicted because of the stages and the proceedings were not followed, and now he decides to challenge in the higher court,
Yes.
is it that judicial review of proceedings is all the judgments where he's been convicted, or the two of them?
He's actually challenging the proceedings of court,
So
not even necessarily the judgment, because if the proceeding is seen not to be followed,
even the conviction is a nullity.
quashed. Exactly.
Okay.
So if the proceedings is not even done the right way, that means there is no judgment. You get no conviction. As we said earlier, you can't place something on nothing and expect it to stand. There's no proceeding, so there's no judgment.
Okay, that's great.
Yes,
Now, counsel, if he must have gotten that judgment or the proceedings, and the higher court says that the lower first court of instance made a very terrible mistake, or they erred in law that the proceedings were not followed, and they discharge him, can he be rearrested or retried again when that proceedings or the prosecutor decide to now follow the proceedings on that same matter? You understand the question now?
Yes,
Somebody is
do.
being charged for murder, and at the end of the day, the proceedings were not followed. He was brought fettered, and he was read. The charge was read in English. Why he's not understanding? And he was convicted. He now appealed. I want you to follow the stages, and he now they looked at the proceedings that he didn't follow it and now quashed it. Now the prosecutor now decide to go back to his house to put his house in order. Can he rearrest that person to start a trial?
Yes, he can.
Okay, that's the point, and make it. I want our viewers to understand. So, for the fact they have quashed does not mean that he is now being discharged and acquitted. No, it's just that the proceedings.
Yes, was not followed through. So that judgment is set aside. Do you get? But they
can now rearrest and retry him.
Exactly.
Okay, that's okay. Thank you very much. Now, in the case where the accused person was not physically present in court, what is the position of law in that?
Okay, it's a general principle of law that an accused person must be present at his trial at all times, and that is from arraignment till the end, which is judgment, sentencing, whatever the case may be. He must be present at all times. However,
okay, there's an exception now?
Of course, there are certain exceptions to it.
Okay.
And those are like where the accused person misconducts himself as to render his presence in court so impracticable. Then when he...
How do you mean by that?
And maybe he has been seen to be a
troublemaker.
Threat to troublemaker, or he disturbs or something of that sort. So his presence can be dispensed with in that instance.
And he will try in absentia?
Yes, in absentia, yes, he will.
And whatever judgment comes is valid?
Yes. Then another case is where he's maybe of an unsound mind. As in that case, he's incapable of making his own defense. So his presence can be dispensed with. Then for reasons of public safety too, in cases like that, yes.
But of course, his representative or counsel must be in court.
But general principle, he must be present from the beginning to the end. And it was seen in the case of Dingi Mohammed versus the state, and then Lawal versus the state. There are plethora of cases, Lawal versus the state, Dingi Mohammed versus the
now, based on these, on national issues based on this, you're a lawyer. We say that the last adjourned date by which this IPOB agitator, the leader, Nnamdi Kanu, was supposed to be in court. The DSS gave an excuse that because of logistics, they couldn't bring him to court. What is your take on that as a lawyer, and based on legal perspective? Is that defense valid in law, that based on logistics, which they didn't explain? That was what was read before the court, and the court has to now adjourn to another further date. What is the position of law on that?
That doesn't, the law doesn't support that. In fact, where a prosecutor has failed to make an accused present in court, or to bring the accused to court, the defense counsel can make an order of mandamus.
What does that mean?
It's an order compelling the prosecutor to bring the accused to court, to release the accused to court. So where that order is made, they have no choice but to release the accused. So in this Nnamdi Kanu's case, him saying logistics, it's not
sufficient.
It's not sufficient. It doesn't make sense.
The case of being logistics incapability, that's why the accused person cannot come to court, is totally unattainable in law. We want to appreciate you for coming.
Thank you very much.
Barrister Onyeji, and don't when next week call you out of your busy schedule, you oblige us.
Yes,
thank you very much
You're
for
welcome.
coming.
Thank you very much for having me.
One of the objectives and essence of this program is to educate members of the public, especially non-lawyers, on the rights and remedies available to them in law. In the course of our discussions today, we learned that an accused person is not supposed to be arraigned in court on chains unless in certain circumstances which the court may decide. Therefore, no police officer or any security official has the right to arraign an accused person fettered. Always remember that it is better to be a law-abiding citizen in order to stay out of trouble. This is because when you and I obeys the law and garnishes it with honesty and good character, the society will definitely be sanitized. As for me and my family, we shall continue to abide by the law and do that which is good and right. What about you? Viewers, this is where we draw the curtain on today's episode of Justify Nigeria. Join us same time, same station, on another fresh episode of the program. Until then, this is Anozechinum, so wishing you the very best. And bye for now. When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individual.
If you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation.
Justice must not only be done, but it must be seen by all to have been manifestly done.